Good morning and welcome to this Travellers hosted event, Whiplash Reforms, a Perspective from Travellers. My name is Alison Manley and I'm Claim and Relationship Manager here at Travellers Europe. I'll just let you briefly read our disclaimer notice and then I shall introduce you to our three speakers today. I'm joined today by three of my colleagues from Claim and Risk Control. Helen First is Technical Claim Manager sitting at our Central Claims team and based in Red Hill. Helen has worked for Travellers for over 25 years, starting as a claim professional in our solicitors' professional indemnity team before moving into the world of business insurance. Today, Helen is the technical referral point for all of our property, liability, and importantly, given today's topic, our motor claim professionals, and has spent the last 12 months or so ensuring that as a business, Travellers are ready to respond to these forthcoming challenges. Amanda Emberton is Senior Claim Legal Counsel, working as inside counsel supporting our claim professionals on technical policy issues and litigation support. Amanda is a qualified barrister who, having worked in private practice, was enticed into Travellers back in 2017. Amanda supports our claims teams, again predominantly supporting our property, liability and motor handlers when the team requires legal input and guidance. We're also joined today by Chrissy de Ravella, one of our senior risk control account consultants. Chrissy has been with Travellers since 2011 and is responsible for managing the survey, training and risk control support services for many of our corporate, transport and public sector customers, amongst others. And I'm sure many of you on the call today will be familiar with Chrissy. As a claims department, we work closely with Chrissy and her colleagues in risk control to ensure that our customers are provided with appropriate support needed to help manage, control and mitigate risk of claims. Before I hand over to our first speaker today, though, I just briefly wanted to run you through our agenda. Amanda will start the discussion on what the reforms are, why the changes are being made and when they come into force. Helen will then speak on what this means for Travellers and our customers, including the pros and cons of the changes. And Chrissy will follow on the benefits of reviewing internal processes and accident investigations. And we will then close up by giving you a feel for what we think are some of the key messages for you to communicate to your business. Now, did you know that the Association of British Insurers state that there are 1,500 new whiplash claims reported every day in the UK? Now, on that fun fact, I'll hand you over to Amanda.
Thanks, Ali. Just before the pandemic, motor claims volumes had plateaued at around 650,000 a year, with 85% of those being whiplash related. So I thought we'd look at some of the background to this. It's been the government's intention for many years now to address the implications of those claims, and the package of measures which now fall under the Whiplash Reform Programme have been a long time in the making. So let me take you back to where it all started. In its spending review and autumn statement in 2015, the government stated its intention to make it harder for people to claim compensation for exaggerated or fraudulent whiplash claims, and its plan to end the right to cash compensation. The aim was to effect a fall of about £40 to £50 a year for car insurance costs for drivers. Balanced against that, it also recognised that it should continue to ensure that genuinely injured claimants receive the right level of compensation. The government consulted between November 2016 and January 2017 on how that could be achieved, and it printed its proposals in February 2017. Those consultation measures were originally put forward in the Prison and Courts Bill in 2017, but in April of the same year, that bill was scrapped as there was no time for parliamentary consideration before the general election. In June 2017, the Conservative Party formed a government with a manifesto commitment to reduce insurance costs for ordinary motorists by tackling the continuing high number and cost of whiplash claims. And in May 2018, the Civil Liability Bill was issued, addressing whiplash and also the discount rate for assessment of future loss in serious injury claims. The Law Society campaigned against the bill on the basis that the whiplash claims reforms would reduce fair compensation. Nevertheless, the Act was passed in December 2018, and numerous regulations have been passed since then to bring it into effect. In 2020, on account of the pandemic, the government announced that it would delay implementation until the 1st of August 2020, and that was further delayed to April 2021. And then in January this year, the government announced in a ministerial statement that the reforms would be delayed again to May. So here we are. And the amendments to the civil procedure rules, including the new pre-action protocols and practice directions, have been published, and it's all coming in force in England and Wales on the 31st of May, after much dither and delay. So now let's look at the headline key features of those reforms before we dig into some detail. The relevant part of the Act here is Part 1, which concerns claims for whiplash injuries, where the duration of the injuries doesn't exceed 2 years. As I've already mentioned, the policy aim is to reduce the amount of damages and costs payable for those claims, at the same time as keeping genuinely injured people compensated fairly. So how's that going to be achieved? First of all, there is a new small claims track limit for road traffic injuries. The threshold limit has been raised from £1,000 to £5,000. Secondly, where the claimant values the overall claim at not more than £10,000 and the claim for damages for injuries at not more than £5,000, the new pre-action protocol will apply, and we'll have a look at that. The Act provides a definition of whiplash injury, which we'll look at, and damages for pain, suffering and loss of amenity are now to be evaluated on a tariff. There is now a ban on offers being made by compensators in the absence of medical evidence. And finally, the MOJ has instructed the MIB to manage the delivery of the new service portal to support RTA personal injury claims that fall within the new SCT limit. The official injury claim service will be accessible to anyone looking to make and settle a whiplash claim, in theory, without the need for court or legal representation. The MIB states that its goal is to make the process simple, unbiased and secure for everyone. The service is designed to integrate with other key insurance industry systems, being the motor insurance database, and will be run separately from the existing claims portal used for higher value fast track claims. So let's put some flesh on the bones of those key features. A new pre-action protocol and practice direction 27B is coming into force. It has a catchy name, Pre-Action Protocol for Personal Injury Claims Below the Small Claims Limit in Road Traffic Accidents. The protocol applies to road traffic accidents which occurred in England and Wales on or after the 31st of May 2021. For road traffic accidents before that date, the £1,000 small claims track limit for personal injuries will continue to apply. The protocol applies where the claimant values the overall claim at not more than £10,000 and the claim for damages for injury at not more than £5,000. Whiplash claims worth up £5,000 are now allocated to the small claims track and are no longer costs bearing. And that's a key point. The protocol is concerned with claims arising out of motor accidents pursued by adults with full capacity who were occupants of a UK registered vehicle following an accident occurring in England and Wales. So that means that there are claimants who aren't included in the protocol, and they're also listed. So those include a child or a protected party, a motorcyclist or their pillion passenger, those using a wheelchair or a mobility scooter, cyclists, horse riders, pedestrians. And then on a slightly different tack, we have undischarged bankrupts, or where the claimant or defendant acts as a personal representative of a deceased person, or where the defendant's vehicle was registered outside of the UK. So where a claim is brought by a child or protected party, it will be allocated to the fast track and must not be allocated to the small claims track. And for those other exceptions, those will be subject to the £1,000 small claims limit. So what is the new definition of whiplash, and how does the tariff respond? The Act defines whiplash injury as an injury of soft tissue in the neck, back or shoulder that is a sprain, strain, tear, rupture or lesser damage of a muscle, tendon or ligament in the neck, back or shoulder, or an injury of soft tissue associated with a muscle, tendon or ligament in the neck, back or shoulder. And the duration of the injury will not, or is not likely to exceed 2 years, where the claimant takes reasonable steps to mitigate. The Act further requires that to be whiplash, the injury sustained is sustained when there is driver negligence, or where the party is injured when they are using or being carried in a motor vehicle on a road or other public place in England or Wales. The Act covers the assessment of damages where a person suffers whiplash alone, or where there is whiplash and a minor psychological injury sustained on the same occasion. And this is done through the tariff, which sets out fixed awards. The tariff might be uplifted in what the Act refers to as exceptional circumstances, but these can be uplifted by no more than 20%. And for this to happen, the court must be satisfied that the degree of pain, suffering, or loss of amenity sustained makes it appropriate to use the greater amount, and either the whiplash injury is exceptionally severe, or the person who sustained the whiplash has exceptional circumstances which have served to increase their pain and suffering. One of the issues which will no doubt arise now is how will exceptional circumstances be applied by the courts? So this table here shows you the whiplash tariff for pure whiplash, where it says tariff no psych, whiplash and minor psychiatric injury, and shows the current JC guidelines for awards and the percentage savings that will come into force as a result of the application of the tariff. And as you can see, the new awards are significantly lower. Medical experts will be aware of those different bands. The government states that it has engaged with Medco and that the necessary training will be provided to experts. And where a prognosis was to stretch across 2 bands, then the higher band should apply. There are no provisions to revise the tariff on a regular basis by a suitable inflationary measure. The Act requires the MOJ to review the tariff within 3 years, and then within every 3 years after that. Helen will now look at how things will work under the new portal.
Thanks, Amanda. Hello, I'm going to be touching on some of the relevant aspects of the new process, but the key message I want to get across is that there are elements where your input and cooperation will be absolutely critical. This is an unforgiving process. So the new portal, it's called the Official Injury Claim Service, and it's been designed with the unrepresented claimant in mind. It's full of guidance and support and looks like other government websites, with large boxes setting out the next steps and radio buttons for making selections. If you've ever renewed your car tax online, it has a similar look and feel to that. However, it's a much longer process with a lot of toing and froing between the parties. Despite online guidance and the offer of a friendly OIC administrator on the other end of the phone, I don't think claimants are going to find it that easy. The claimant user guide itself, which has only been issued in the last few days, runs to 64 pages. We've been given access to the training system, and we've been playing the role of both claimant and compensator, and it's quite challenging. I've heard estimates from leading claimant bodies suggesting that they expect that only 5 to 10% of claims coming through the new portal will be brought by claimants acting on their own behalf. The rest will have either lawyers or claim management companies acting as representatives. To support this, many are anticipating an increase in legal expense insurance, plus a number of claimants are expected to be willing to forego some of their damages to have lawyers bring the claim on their behalf and take a cut. In addition, it seems that there'll be no advertising for the new portal. And if you do a Google keyword search, say for car accident, it's not going to appear anywhere near the top. Most of the big accident management companies and lawyers will appear first. And it's not just claimants who may struggle with the portal. There are plenty of pitfalls for compensators, and our claims handlers will need to have their wits about them. We'll come on to some of those a bit later. So, routing to the right compensator. In theory, this should all work, but we're not going to be able to test anything before we go live. All TPAs and insureds handling their own claims within an excess will need to register themselves on the new portal and obtain a unique pairing ID. This enables travellers to link in with that TPA or insured and allocate new claims to them on the portal. The way all new claims reach us is by matching the vehicle registration number provided by the claimant to the insurer named on the Motor Insurers Database, or MID. Where there is a TPA or insured handling claims, another code will link them to the relevant policy and should then route the claim directly to them. I'm told by the OIC Support Centre that if a claim comes to travellers that should be handled by a TPA or self-administered insured, we will be able to redirect it via the portal, and then all subsequent notices on that claim will go to the correct compensator. Where our insured has a vehicle out on hire, the other insurer will usually be on the MID as well as travellers. In those situations, the claim will be allocated to the portal support centre, who will contact both insurers and allocate the claim to the one that accepts that they're in the frame. Where the other insurer isn't on the MID, the claim will come to travellers, and our claims handler will then need to make inquiries with the insured to establish who the other insurer is, contact them to obtain their agreement to take on the claim, and then contact the portal support centre, who will reallocate it. Where our policyholder is driving a customer's vehicle, the reverse should happen. So the claim will automatically go to the customer's insurance company, who will hopefully contact us, and we will agree to take the claim over. The customer's insurer will then liaise with the portal support centre, who will transfer the claim to us. Ideally, we'll know about these accidents before the claim comes in. So if it's a fault claim, we can be proactive about contacting the customer's insurer and putting them on notice. What's on the MID is central to the whole portal routing process, so it's really important to get vehicles uploaded or removed promptly. The new protocol gives us 30 working days to provide a response on liability. The options available are to admit liability in full, to admit in part, to admit liability but deny that an injury was caused, and finally to deny liability. Compared to the 15 days we get now in the RTA portal, that 30 days may seem like a luxury. However, there's a serious downside. If we don't get one of the 4 formal responses submitted in time, instead of the claim just dropping out of the portal like it does now, we are deemed to admit liability in full. To compound matters, if the claim isn't settled and proceedings are issued by the claimant, that default admission is binding on all elements of the claim, including any losses that might fall outside the protocol, such as credit hire, which can be costly. Equally, if the claim increases in value so that the whole thing comes out of the low value protocol, we'll be bound by the admission. Even worse, it looks as if the protocol doesn't allow the compensator to introduce a medical causation defence where there was a default admission. And lastly, although an admission isn't binding on other linked claims arising from the same accident, it might well be persuasive. It's therefore a good idea to establish as much information at the scene as possible about what other claims may follow and whether any of them could be significant. Where our response is anything other than an admission in full, we have to submit a defendant's version of events. This is basically the driver's account of what happened. It will need to provide enough detail to support a denial or partial denial if that's what our decision is to be. The driver will also need to sign a statement of truth, confirming that they believe the facts stated to be true and that they acknowledge that they can be found guilty of contempt of court if they make a false statement without an honest belief in its truth. If we don't have the driver's version of events by the 30-day deadline, then we can still issue a denial or partial denial, and the claims handler will have to submit a witness summary with signed statement of truth. This doesn't really do much more than buy us a bit of time, as the claimant can issue proceedings in the absence of a full admission. The claims handler will only be able to provide the information that they know, and without the driver's explanation of what happened, it's unlikely this will be very persuasive in front of a judge. We'll therefore need to keep pushing for the evidence from the driver so that it can be submitted when it comes to a hearing if the claim is pursued. And lastly, the driver should be asked to note whether they think any other parties were not wearing a seatbelt, as the protocol makes provision for this to be argued on settlement of the claim. The claimant has to state on the initial notification whether or not they were wearing a seatbelt, but how contentious this may be remains to be seen. I just want to say a bit about the settlement process. There has been talk for a while about pre-med offers and whether they should be allowed. This is basically where a compensator makes an offer of settlement to a claimant based only on a description of their injuries and before having seen any medical report obtained from an expert. It's been seen as a driver of claim frequency for whiplash claims, and the new rules ban the practice for any whiplash injury. Working out how a claimant in person goes about getting their own medical evidence has no doubt been something of a challenge in the new process. The new protocol, supported by the portal, has come up with a solution that relies on the use of Medco-registered experts who will receive an automated instruction from the portal triggered by a request from the claimant. Where I think it gets tricky is if the claimant wants a second medical report, usually because the first expert recommends one. That doesn't have to be done through Medco, and the claimant can ask the compensator to arrange it for them if they are unrepresented. There are time limits for the compensator for doing that. Once the claimant has received the medical report from the expert and they're happy with it, they can then submit it on the portal and indicate to the compensator that they're ready to settle. The first offer is made by the compensator, and each side can make up to 3 offers, hopefully landing on a sensible figure somewhere in between. With whiplash claims, the offer for the injury element, known as pain, suffering, and loss of amenity, must be in line with the tariff that you saw earlier, which is determined by the prognosis period the expert puts in their report. However, there will still be plenty of room for negotiation on other losses, such as loss of earnings and property damage. And of course, where there is a non-whiplash injury, that will be valued in more traditional ways. This will be unfamiliar to a claimant in person, and there's a fair bit of concern about how they will be expected to have any sort of understanding of what a reasonable offer is. What we've seen on the test system doesn't help much. There's a note for the claimant when looking at their offer that says they can seek advice on the valuation of their claim or refer to the FAQ section of the website. But that's not working in the test system, so we don't really know how helpful it might be. Added to that is the ability for a claimant to claim an uplift on a whiplash offer where they consider their injury is exceptionally severe and that they have exceptional circumstances, such that an uplift, which is a further 20%, is justified. Again, there is a firm expectation in the industry that this is going to lead to some problems, as there's no real guidance for either party on what that actually means. What we do know is that it's extremely easy for the claimant to claim this uplift. The way the notification form is laid out almost leads them to it, as they have to answer the questions about whether it applies in their case. Just a couple of points here to mention on mitigation. The new process does still provide us with opportunities to help the claimant with certain aspects of their claim to minimise the cost. In relation to the injuries, the claimant is asked on the initial claim form whether they've been asked to seek medical treatment. We'll be looking out for that, and on cases where we're admitting liability, we'll be referring the claim to our in-house medical team, who'll then liaise directly with the claimant to help them with any rehab, usually in the way of physio. This allows us to control the cost by using our own providers, and also gives us access to information about the claimant's injuries and recovery that will be helpful in assessing the claim. The claimant will also indicate on the notification form if they need any help with a replacement car or with repairs to their vehicle. If the claim comes in quickly enough and we're able to make an early liability decision, we may be able to avoid expensive credit hire or storage charges by using our own networks to provide those services to the claimant. Of course, both these opportunities will only work if the claimant has not already been swept up by an accident management company, who'll be providing all of those services through their own linked organisations. I'd just like to say a few words on litigation in the new process. The protocol invites the claimant to issue proceedings at many steps along the way, and these are listed on the slide. Where the claimant receives a denial of liability or a partial admission, they can issue proceedings which will then be heard at a liability-only hearing. If the judge finds that the defendant has some liability, the proceedings will be stayed or paused, and the claim will then continue back in the portal. The claimant can also issue if they don't like our offer, or if there's a dispute over a request for an interim payment or payment of fees. There are all sorts of opportunities to issue if we missed a deadline for something. And lastly, they will have to issue proceedings if the 3-year limitation period from the date of the accident is approaching, and the portal gives them plenty of warnings about this. The portal makes the process of issuing proceedings fairly automated. The claimant just needs to tick a button to say that they want to go to court, and the portal does the rest. However, there is a lot of printing involved, as the claimant has to print off the court form, a statement of truth, and all the relevant documents. Coupled with the fact that they also have to pay the court fee up front, I think this may be enough to put many off. Will they be able to change tack and go back to accept a previously rejected offer? No, it doesn't look like it from our testing. As soon as proceedings are issued, the claimant gets a message to say the claim has now been closed and the court will decide what happens. Not really very claimant friendly. Another crucial point for the claimant is that where there are vehicle-related losses that result from the accident that they're not personally paying for, such as credit hire or their own insurer's outlay, the burden is on them to find out what those costs are and include details in the proceedings. I think there's enormous potential for this to get missed, so those organisations lose out. But equally, that means it's even more likely that where those sorts of losses do exist, there'll be a representative acting for the claimant. I hope the last few slides have given you a flavour of how the new rules will operate and what we really need to watch out for when we're handling these claims. Your drivers can really help us with this by noting as much information as they can from the scene following an accident, and you'll hear more about this a bit later. Just a few other points to make you aware of. Firstly, when the new small claim notification form or SCNF comes in, the portal also creates a defendant's version. The protocol states that the compensator must send this to the defendant as soon as practicable by first-class post. We're still largely working remotely, so as soon as practicable could be some way off. We'll therefore be sending these forms by email, either directly to you or to your broker. Do be aware that where the claimant is represented, it's the representative's responsibility to send you this form. Please do be very mindful of that 30-day deadline for your driver's version of events. We'll need all drivers to know how significant this is because of the deemed admission, and be ready to complete the form in good time. There's a template annexed to the protocol, but we'll also be making them available if required, and we'll send one out to you with all new portal claims that come in. Even if nothing has been received on the portal, do get your driver's description of what happened as soon as possible, so we're on the front foot if and when a claim does come in. And lastly, there is only a very small window of 5 days for us to nominate solicitors once the claimant has told us they intend to issue. If we haven't nominated solicitors, then the proceedings will come to you directly, and we'd ask that you just send them straight on to us. So, what are the benefits for defendants and insurers of the new system? The two big pluses envisaged by the reforms are both related to reduced outlay for insurers, which is meant to drive down premiums. These savings will be seen firstly on claimant solicitors' costs, as more claims should fall below the small claims track, which means defendants don't have to pay costs if they lose. The other saving is on the far lower awards for whiplash injuries. I think it's quite possible that we'll see shorter cycle times for many of the more straightforward claims, where claimants do manage to bring the claim themselves on the portal. It will depend to an extent on the waiting times for medical examinations and reports, but I can't see that being slower than it is now. Without the delaying tactics of some claimant solicitors whilst they build their clients' claims, I think we'll see a lot of injured parties just keen to get their compensation as quickly as possible, perhaps particularly with the events of the last year, which will have left many short of funds. Also, there's the longer investigation period under the new rules than we have currently. This may be helpful where we have some information but need a bit longer to firm up our position and obtain the relevant evidence. And lastly, there's no doubt that what is meant to be a user-friendly claim tool for the layperson is going to present quite a challenge for even the most savvy claimant. Just getting to the end of the initial notification form will be an achievement, and I do think we may see a number of those claimants simply deciding it's not worth it and giving up. I mentioned the longer investigation period as a positive on the last slide, but actually, because claims will no longer simply fall out of the portal in default of a decision, it's not much of a positive. I think for many, the deemed admission may outweigh any benefits of the longer investigation period. We may see claims being made for very minor injuries by claimants who previously would have had no real way of bringing those claims. Essentially, the new portal provides an avenue that hasn't been there up till now for pursuing those really small claims. One of the key pros of the new process relates to the savings that have been envisaged as a result of the much lower awards for whiplash claims. Those savings, to some extent, may be lessened because the claimant is able to claim the 20% uplift. As we touched on earlier, there's no real guidance on what this looks like, and lots of arguments on the point are expected to follow through the courts. The new portal has far more touch points than the current portal. This is partly due to the messaging facility, which means the claimant can send a message to the compensator as often as they like. In addition, the claimant can upload evidence, documents, and new losses at any time. The portal will need to be monitored several times a day to keep track of all this activity, creating a much greater operational burden. The ability for claimants to bring their own claims will be appealing to any fraudsters looking to make a few quid following an accident, and I'm sure that they will have the motivation and the skills to pursue such claims all the way. I mentioned previously the other financial saving around reduced solicitors' costs due to the higher small claim limit and the claimant-friendly portal. Of course, claimant solicitors aren't simply going to take that on the chin, and we fully expect many of them to remodel and turn their attentions to other claimant markets, such as pursuing data protection breach claims or cyber claims, both of which seem to be on the rise, or the more traditional EL and PL claims. There will also be those lawyers who operate as part of larger organisations, providing the full claimant experience to injured road users, including rehab and credit hire. Those claimants will have representatives acting for them, who will recoup their costs through inflating the claim, either by way of recoverable disbursements or through claiming non-whiplash injuries. In many cases, this may increase the value of the claim to more than the new £5,000 limit, and it will fall outside the new process anyway, and solicitors will then be able to recover their costs from the defendant in the normal way. I'd like to finish by giving you a brief update on what we've been doing at Travellers. Firstly, we've been liaising for the last few weeks with our TPAs to ensure that all the claims that they should be handling will be getting to them. We're also having conversations with our self-administered insureds. It's unfortunate that we won't know until we go live whether all the background routing works, but we certainly know a lot more about it now than we did a few weeks ago. In terms of our own claims handling processes, we're making some changes to our file management system so that claims handlers will be able to easily spot OIC portal claims in their work queue. Excuse me. I've talked about the numerous touch points on the portal, and many of the work items that get generated aren't going to need prioritising. So we're looking at how we can use our system to get the right balance between jumping on anything that is urgent and not neglecting all other work. As part of the claims handling process, we're also looking at our standard templates and making some changes to help drive a proactive and streamlined investigation. We're also tweaking our data screens so that we can capture management information, particularly around the frequency of claims in the new portal and Whiplash awards. I mentioned already the testing that we've been doing for a few weeks now. Primarily, we focused on our motor claims handlers, who will be the end users of the portal. The testing has given us a really good insight into the process and will also serve as the training for those users, so that when it goes live, they're already familiar with the portal and will know what to do. We already have a comprehensive process for referrals to our fraud team, and we'll be making sure that claims coming in through the new portal will be prioritised as part of that process. We're also looking at our rehab referral process, so we can make sure our medical claim team can get involved early on in any suitable cases. Lastly, we've put together a programme of communications, both internally and externally. This webinar is one product of that work, but we've also sent out bulletins and been speaking to our customers. So I hope that gives you a flavour of what's coming down the line. I'm going to hand over now to Chrissy.
Thank you so much there, Helen. Certainly a lot of information to take on board, so many thanks. And we just thought we'd use the kind of last part of this webinar today to remind us all that in addition to routinely checking the effectiveness of the controls we employ to manage occupational road risk, really whenever there is a significant change, it should act as a catalyst for organisations to check their approaches to make sure that they remain fit for purpose. And we currently find ourselves in a position where we've actually got two significant changes going on. Firstly, the legal changes that we're just been hearing about, so I won't dwell on that for now. But secondly, we have the impact of COVID. The pandemic has meant different things for different organisations. Some businesses have managed to continue as normal. Many have had to make significant operational changes, and sadly, some have not survived. The changes that we've seen over the last 12 months have altered the profile of our roads, and some of the most recent figures that have come from the Department for Transport showed us that the motor traffic levels fell by 30% during the first 6 months of 2020, during part of which we were in a national lockdown. But now we're returning to a state of normality, she says with her fingers crossed, and the profile is changing yet again. So we have drivers who have been away from the wheel for some time, so there's absolutely an element of unfamiliarity for those drivers. We've got drivers who are returning to undertaking longer journeys, so we've certainly got a risk of driver fatigue coming into play. And then there's also an element of anxiety, or there may be, sorry, an element of anxiety as people start to venture out again. And sometimes when we get anxiety, it plays out or could play out in the form of negative behaviours on the road. And then finally, we've also got those drivers who remained actively driving throughout the pandemic. And for those individuals, there may well be an element of frustration as our roads become busier once again. So not only have many organisations faced operational changes, the profile of our roads and possibly our drivers has also altered. Organisations have a legal duty to put in place suitable arrangements to manage health and safety, and the management of occupational road risk is absolutely no exception to that. The Plan, Do, Check, Act model is really well recognised and provides an excellent foundation that can be scaled to suit the size and nature of any industry sector. Here on the screen, you can see a little bit more detail around the Plan, Do, Check, Act components. And using this model, I'd like to explore some of the aspects that you can consider when you start to complete the review of your internal processes. So starting with the first component, plan, I'd say some of the things to look out for is making sure that you've still got top level commitment to the management of occupational road risk. The commitment that's shown from the top certainly sets to help the tone and culture, and as that flows through the business, or how it flows through the business. It's also a good time now just to double check that roles and responsibilities are clearly set out and that everyone understands what's expected of them. Certainly those with elevated levels of responsibility within the business need to make sure that they've got the necessary authority to influence, and also that they can effectively flow and communicate information down through the business. Now is certainly a good time to review your risks associated, so revisit your risk assessment. And I would say that spans all of your transportation activities, taking account any of the operational changes and also taking into account the profile changes I've just mentioned. And then finally, double checking that your policies are in place and that they're comprehensive and that they cover all the relevant topics. For example, driver training, journey planning, vehicle maintenance, the list goes on, but also on there, don't forget accident reporting procedures. And double check that these policies and procedures have been communicated and cascaded through the business. So moving along the cycle, we come to do. When reviewing do, some of the elements to consider include making sure that departments that have different responsibilities in respect of occupational road risk cooperate with one another. And this is particularly important when we've got large or complex organisations. And it's really about just making sure that nothing falls through the gaps. It's also about making sure that you've got adequate systems in place to manage your road risk effectively. For example, if your policy states that each driver is to do a pre-use vehicle check, now is a good time to double check that you've actually given them the tools to enable those pre-use vehicle checks to take place. Have we given those individuals sufficient training? Do they know what they need to check? Do they know how they record the information? Etc. So now's a good time to have a look at your systems to make sure that they're in place. And I'd also say, with regard to this piece, it's an important time to actually involve your workers or their representatives and talk to them about the management of occupational road risk and the decisions you're making and the reviews you're undertaking. As this is not only a good way of communicating with them, but it's also about ownership and empowerment. And finally, under this component of the cycle, I'd say double check that you've provided training and instruction where necessary, remembering that many of your drivers may well have been furloughed or certainly not driven as frequently or for such distances for some or for many months now. Continuing along, we come to check. And this is the first thing to look at here is just make sure that you've got suitable systems in place to be able to monitor your performance, which will help to decide or define whether your policy is effective and whether it's been implemented correctly. So, for example, if your policy says you're going to do something, for example, route risk assessments or driving license checks, have you actually achieved what you said you were going to do? And if your review of this area transpires that actually you're not doing what your policy says so, now is a really good time to start to draw up an action list and prioritize those. And certainly escalate any of those concerns upwards if you need to seek additional resource to get things moving or get things actioned. And also now is a good time to remind all employees that they really must report all work-related road incidents or near misses, no matter how minor. The incident statistics that organisations gather certainly help them to better understand how they're performing. And if we have failure to report incidents by our drivers, inevitably it's going to skew the figures and could lead to a situation where you're not learning from losses. And finally, we come to ACT. Although in the real world, I feel I need to point out the plan, do, check, act model is actually a cycle, which leads to that continuous improvement piece. But under the ACT component, some of the parts to look at is making sure as a business that you're actually collecting enough information which enables you or allows you to make informed decisions about the effectiveness of your existing policy. So it's a good opportunity to review what sort of information you currently gather and consider whether it's sufficient to give you enough information to make informed decisions. And finally, regularly revisiting your road risk policy, to see if anything requires updating. You know, is this something that we can learn? Is there something that's stemming out of legal changes? For example, the changes we've just been hearing about in the early part of this webinar. Can you learn anything from the incidents that you've encountered or that those around you have suffered? Or even is there emerging technology that's coming to market that's designed or intended overall to improve your occupational road risk exposure? So go back and revisit that policy. So moving on, I'd just like to spend a short amount of time taking a closer look at incident reporting and analysis. And you will note on this, I've called it incident analysis rather than investigation. It's a small play on words, but the words we use and the approach that we take really can have a significant influence on the results that we achieve. The word analysis being slightly softer and really meaning what we're trying to do is break down the situation into various elements and then asking pertinent questions to draw some conclusions. And certainly in the purest safety area, it's absolutely not about apportioning blame. Inevitably, when an incident does happen and it goes through the analysis process, an organisation will use a variety of sources of information, be that from the scene itself or from reviewing documentation such as vehicle maintenance records, through to conducting interviews. And sadly, we don't have time today to explore all of those elements. However, with the pending changes that we've been hearing about, I think just spending a moment to talk about on-scene information is absolutely critical. And it kind of goes without saying, once it's gone, and therefore educating and training our drivers to collect as much on-scene information as possible is going to be really essential for all businesses moving forward. So in the event of an incident, clearly the driver needs to protect their own safety and preserve the life of others. That comes first and foremost. Once that's been achieved and it's safe to do so, the process of gathering scene information can start. And on screen now is a list of scene-related information that we'd encourage your drivers to gather. I think everything listed is fairly self-explanatory. However, I think it's important to kind of point out, depending on your own unique fleet, there may be additional aspects that you'd want to list, but hopefully what you see on screen really does give you a good starter for 10. And finally, to conclude, and you can all call me old school if you wish to, but I'd encourage you to make sure that every vehicle that you have within your fleet has a pencil, a piece of paper, and a good old checklist that can act as a prompt for the driver to follow in the event of an incident occurring. Also sitting alongside that, just make sure that you give them key points of contact, so who can they get in touch with within the business. And the reason I take this old school approach is that when somebody is involved in an incident and we have adrenaline that's flowing, it can be really, really difficult to recall what sort of information you need to gather or what you need to do. So as organisations, the more support that we can provide to our drivers, we'd hope for the outcome to be better. And with that, I will pass you over to Ali. Thanks, you.
Chrissy. And thank you to all of our speakers today. I think it's been a really insightful session. Some of the key messages that I've been taking away from today's session, and obviously our practice sessions that we've had before, were that, you know, input and cooperation from everybody, whether that's our customers, our brokers, and indeed our own claims department, is going to be crucial for us to be able to respond to these reforms. And I think actually it starts before a claim has happened, in making sure that the MID is kept up to date, and that, you know, if you sell a vehicle on, you're removing that from your MID list as quickly as possible, because I'm sure nobody wants to be in a position where a vehicle still showing on your MID and you're having to scrabble around trying to find paperwork to prove the sale of that vehicle 2 years ago, perhaps. So that seems like it's going to be important to me. On top of that, I think, you know, you've really all provided us with lots of information to say that, you know, gathering everything that you can at the scene of the accident is really going to be paramount here. You know, drivers need to be aware that we will need to know how many vehicles were involved and how many passengers were in each of those vehicles, and did they appear injured, and if so, how severe did those injuries seem? Could you tell whether or not they were wearing seatbelts? Obviously something Helen touched on before. And, you know, getting all of that information into us either directly or via the broker as quickly as possible, including details of the driver and his contact details, so that we can come back to them and ask more questions if there are some outstanding investigations to be undertaken, so that we can try wherever possible to avoid that 30-day deadline and that binding admission of liability being issued. I mean, would you say I've got a good flavour for what the key messages are, or am I missing anything?
No, I think you're absolutely right, Ali. You know, the on-scene information is going to be so crucial for helping to build up an accurate picture of what's going on. And as I say, I think by giving a checklist to our drivers is certainly going to help them with that process.
Okay. So on that note, that brings us nicely to the end of our presentation today. Up on screen now, you've got the contact details for both myself and for Helen. If anybody has any other questions at all about the forthcoming Whiplash reforms and would like some more information, then please do get in touch with either of us and we'll be glad to help. But with that, I'd just like to take this opportunity again to say thank you to all of our speakers, Helen, Amanda and Chrissy, and thank you for joining. Thank you.